My lady, I'm on page 13 of our speaking note. I'm about to turn to the case of Greenway and Johnson Matthey plc, which I approach with some trepidation because I know some members of this constitution heard an appeal on it last November.
Yes, and I suspect judgment will be given before Easter.
Right. It may be that we may need to...
So you may not need to say, I don't know,
Yeah.
but I'm not sure how much can usefully be said about it, but no doubt you will say something.
Yeah. The case is in volume 1 at tab 7, MS 624. And the facts were it related to employees who had, in breach of the employer's duty, been exposed to platinum at unsafe levels, leading them to develop platinum sensitization, which the courts below held fell short of actionable physical injury. And the courts below went on to, and it's this part of the case on which we rely, the courts below went on to reject an argument that a term would be implied into the contract to protect the employees from economic harm, and said that the classic formulation of an employer's duty to his employee focused on protection from physical injury. If I could just briefly go to the judgment of Lord Justice Sales at MS 636, paragraph 36. MS 636, paragraph 36. He quoted from the judge, Mr. Justice J. And at letter F, he said, in my judgment, in circumstances where the law imposes an implied term in view of the relationship between the parties, essentially for reasons of policy, and that implied term is in substance the same as the tortious obligation, which arises for exactly the same reason, it seems obvious that the exercise embodies a consideration of the scope of the rule or principle of public policy which creates or impresses the duty. And in my judgment, the scope of the rule of public policy in operation in these cases and all cases of employers' liability is to safeguard the health, safety and welfare of employees from the careless acts and omissions of their employers, and in any event, and in the event of breach where personal injury is suffered, to require the payment of condign compensation. The concepts of health, safety and welfare properly understood embody the notion of protection from personal injury and not from economic or financial loss suffered without personal injury. Put another way, it is because the implied contractual duty is precisely conterminous with and reflects the obligations imposed by the law of tort, and in particular the tort of negligence, that the outcome must be the same, however the cause of action is sought to be classified. That, of course, is in line with the White and Frost case. And at paragraph 37, Lord Justice Sales said, I agree with this reasoning. The classic formulation of the duty owed by an employer to an employee is focused on protection of the employee from physical injury, not protection from economic harm. Albeit if there is a physical injury, then damages may be recovered for consequential loss of earnings. And this is true both in contract and tort. See Wilson's and Clyde Coal Company Limited in English per Lord Wright, quoting Lord Watson's speech and Smith and Charles Baker. At common law, a master who employs a servant in work of a dangerous character is bound to take all reasonable precautions for the workman's safety. Spring and Guardian plc per Lord Wolfe. In the earlier authorities, the courts were prepared to imply by necessary implication a term imposing a duty on an employer to exercise due care for the physical well-being of his employees. Having regard to the general policy reasons which inform the analysis of whether a standard term or duty of care should be implied into a contract of employment, in my view, the proposed term or duty to hold the employee harmless from economic loss should not be taken to be implied. I won't read them out, but we've also referred in our speech to paragraph 47, where he considers Spring and Guardian assurance. My lady, in the course of our research for today, we did find a case where the Court of Appeal, without hearing argument on the point applied, or full argument on the point, applied the implied term in the context of litigation between employer and employee. If I could just hand that up. It's a case called Singh and Reading Borough Council and another, reported in the 2013 One Weekly Law Reports at 3052. And the facts were the claimant had been employed as a head teacher by the local authority, but had brought a discrimination claim against his employers in the employment tribunal. And he alleged that during the course of that discrimination claim, the employer tried to suborn a witness and put pressure on a witness to give false evidence in the employment proceedings. And so the claimant was applying to amend his employment tribunal claim to allege that that amounted to an effective constructive dismissal because of a breach of the implied term of trust and confidence. And the argument in the case largely proceeded in relation to the boundaries of witness immunity and litigation immunity, the employers contending that whatever happened in relation to the witness was covered by the absolute immunity, an argument which the courts, the judge and the Court of Appeal rejected. But in paragraph 19 in the judgment of Lord Justice Lewison, or so I should say at paragraph 17, the judge first of all refers to the fact that the employer took its stand on the ground of judicial proceedings immunity, and that's the only issue that falls to be decided on this appeal. And then at paragraph 19, Mr. Allen also submitted that the implied term that the employer may not, without reasonable and proper cause, conduct itself in a manner calculated and likely to destroy or seriously damage the relationship of confidence and trust between employer and employee, was not engaged where the employer and employee were engaged in hostile litigation. The point was not one that featured in the written skeleton arguments and consequently has not been fully argued. But as present advised, I do not consider that it is a good point. Mr. Allen argued there is no common law duty of care owed by one party to litigation to his opponent, and that proposition is vouchsafed by high authority, see Jane and Trent. So far, so good. The next step in the argument, as I understood it, is that because there is no duty of care at common law, there is no implied term that is engaged by the conduct of litigation. In my judgment, that is a non sequitur. The law of tort, in which duties of care play a crucial role, is concerned with default duties imposed by the law on parties who have no contractual relationship. But where parties are in a contractual relationship, their rights and obligations are, at least in the first place, determined by the express or implied terms of the contract. I do not doubt that in many cases, hostile litigation between employer and employee can damage, if not destroy, the trust and confidence that exists between them. But the implied term accommodates that because it only applies where the trust and confidence is damaged or destroyed without reasonable or proper cause. If litigation is properly conducted, there will be no breach of the implied term. Our case is concerned with an allegation that the litigation has been improperly conducted. Moreover, Mr. Allen accepted that if the boot had been on the other foot and it had been the claimant who had attempted to suborn witnesses, the council would have been entitled to dismiss her for breach of contract. What is sauce for the goose? So the context there was that that was a case where the employer essentially could be said to be abusing the process of the court because the employer was, so the allegation went, attempting to suborn a witness. We submit that it's rather different from holding that the reach of an implied term of trust and confidence or the law of tort would extend to the mere negligent conduct of litigation by an employer. As I say, the court hadn't heard full argument on the point, and so cases that we have looked at, such as White Frost are not cited in the list of authorities which were before them.
Would you say it's right or wrong?
Well, I don't need to go so far as to say it's wrong, because we say it's nothing to say about the case of the conduct of a negligent defence. But I wouldn't go so far as to say that if an employer is misusing court proceedings in an abuse of process sense against an employee, one can see that sort of dishonest type of conduct the law might want to find a duty of care for that somewhere.
Well, is that just between employers and employees, or is any abuse of process actionable?
Well, of course, I hesitate to wade in.
What about the Star Sea? Why wasn't the manifest shipping? The logic of what you say is that that should have been actionable, or at least.
Well, I don't get me.
Ground for avoidance.
No, I don't want to say it is actionable. I think if I've said that, I don't go that far. As I say, the Court of Appeal hadn't heard full argument on the point, and in a sense, it's a very different case from the case we've got. I don't go so far as to say it's rightly decided, but what I don't need to do is, I don't need in this appeal to go as far as to say it was wrongly decided. But it is difficult. Some of the comments that are made about duties arising out of the contractual relationship rather than the tortious relationship are difficult to see how that would square in the context we're in with what was said by Lord Steyn and Lord Hoffman and others in the White and Frost case. My lady, turning to policy, which is page 14, we've set out in our case at MS 51 to 53 the particular policies we rely on. Can I just particularly draw attention to this, which is, of course, there is and has been since the Woolf reforms, if not long before that, a generally recognised public policy that it is best for parties to try and resolve their disputes without litigating them, and parties are under a constant duty to review whether or not a case can be settled. But as we say at MS 51, little paragraph A, implicit in a duty to defend effectively is a duty to defend in the first place, which is difficult to reconcile with that policy. Conversely, and we've looked at this in the context of the malicious prosecution and other cases, there is a public policy that litigants should not feel inhibited in bringing their case before the courts. And it's very easy after the event, when litigation is lost, for someone to say, well, if only you had also called witness X, or if you had instructed expert Y, or if you had not chosen witness X, then a different outcome could have resulted. And fear of that will have a chilling effect, we submit, on the willingness of parties to litigate, although there's a sense that the employer will be damned if he does and damned if he doesn't, because if he goes to court and loses, he may be criticised for not having settled if the employee is subject to criticism. Even if he goes to court and wins and ends up winning on, say, causation rather than breach, an employee may have grounds to criticise him or her. But equally, if he settles, an employee may have grounds to criticise on that basis if he admits any part of the other side's case. We also say that the postulated duty, and this is little subparagraph E, is in truth unworkable. Because it's not uncommon for witnesses to have suggestions about other people that might be called and so forth, and how litigation might be run. If one elevates that into a duty owed to particular witnesses, then how is one to resolve any dispute between the parties as to what the proper way of defending the case is? And of course, this really goes to the question of the implication of a term as well, because how could a term be implied which would deal with that? Because presumably one would also have to imply some sort of dispute resolution procedure into the contract if the employer is to be confident that if he follows his own way rather than the employee's way, that he's not just opening himself to further litigation. And if one's going to go down that route, how can one say that's necessary, or which procedure should be implied? It may also lead to defensive practice in relation to employers being quick to find conflicts at an early stage in order to protect themselves. Certainly they may be well advised to notify potential witnesses or employees for whom they're vicariously liable that all rights are reserved in relation to them.
Doesn't this link up with the sort of problem that arose in a case called Medcalf and Wetherall about
The wasted costs case.
on wasted costs? But I mean, it links up with what the subject you're going to come to, I think, namely legal professional privilege.
Yeah.
But how can you investigate the propriety of the conduct of litigation without a complete waiver of privilege, which can't be expected unless it's obligatory?
Yes.
I think the argument against you is that it's obligatory because of common interest, but assuming it's not, it's an impossible position.
Yes, and we do rely on the fact that privilege would have to be waived to defend a case like this as another policy reason why the
I mean, I have no idea whether the police are insured or not, but I mean, they could easily be insured, and everything. We might find out that that had a considerable part to play. But
well, of course, it introduces another layer of conflict, because where there is an insurer, the insurer may be reluctant to see the employee's interests promoted above what the insurer thinks is in the best interests of the litigation.
right. Well, they have the conduct of the litigation,
yes.
Usually.
And of course, that conduct is regulated by a contract, which is expressed and detailed in its terms with the employer. But the employee has no such detailed terms.
We haven't got Medcalf, have we? But,
We haven't got Metcalfe, I'm
But
afraid.
I'd be interesting to look at it, or it might be interesting.
We'll ensure
About
it's
15
brought
years
along
ago,
tomorrow.
isn't
We have brought along the manifest shipping case. We managed to get that over the short adjournment.
Well, there's a lot in it which isn't relevant to this
There
case.
is, but it's particularly paragraphs 73 to 78 of Lord Hoffman. I won't take the court to them now, but Lord Hobhouse, in paragraphs 73 to 78, deals with the point that once essentially a claim is issued, all bets are off in
It'd be
relation.
helpful to have a copy without looking at it.
Thank you.
Thank you.
We do also,
Thanks.
sorry, before I should say, it's paragraph 73, Lord Hobhouse speech. Page 503 onwards. And at paragraph 74, His Lordship said, before the litigation starts, the parties' relationship is purely contractual, subject to the application of the general law. If one party has a right, such as that given by Section 17, it derives from the contract itself or from the application of the general law to the contractual relationship. These rights continue unimpaired unless one party has exercised a right of avoidance or termination. The insured has or may have a claim against the insurer. The insurer may have accepted the claim or may have rejected it. The insurer may have done so in a manner which evinces an intention not to be bound by the contract, or more probably may simply be requiring to be satisfied that there is a valid claim covered by the policy, but the insured will either have or have not a cause of action against the employer. Indeed, in relation to CTL cases, in the present case is such a case, the English doctrine of ademption makes the date of the issue of the writ the determinative date for deciding upon validity of the notice of abandonment. And when a writ, paragraph 75, when a writ is issued, the rights of the parties are crystallised. The function of the litigation is to ascertain what those rights are and grant the appropriate remedy. The submission of the defendants in this case is that notwithstanding this, one party's conduct of the litigation can not only change that party's substantive rights, but do so retrospectively, avoiding the contract ab initio. It cannot be disputed that there are important changes in the parties' relationship that comes about when litigation starts. There is no longer a community of interest. The parties are in dispute and their interests are opposed. Their relationship and rights are now governed by rules of procedure and the orders which the court makes on an application of one or other party. The battle lines have been drawn and new remedies are available to the parties. The disclosure of documents and facts are provided for, the appropriate sanctions, the orders are discretionary within the parameters laid down by the procedural rules. Certain immunities from disclosure are conferred under the rules of privilege. If a party is not happy with his opponent's response to his requests, he can seek an order from the court and so forth. In relation to policy, we also draw attention to a point made by the academic from Pembroke College, Nick McBride, Volume 5, tab 52. It's just in a case note he's written, the MS 1805.
He's making the same point that you've made, isn't he, Mr. Warnock?
Essentially.
It might slow things up.
Yes, essentially.
You have to look over one's shoulder at one's obligations towards witnesses.
Yes. He's concerned about the impact that may have on claimants with valid claims.
Yes.
It's at the very end of his article on MS 1808, the last paragraph. And we say that whilst unpleasant allegations may be made against non-parties in the course of civil proceedings at the end of the day are personal to and binding only on the parties to them and no one else. And protection is afforded to employees by the fact that a false statement made out of court by an employer may be the subject of a claim in defamation. An inaccurate reference, if one is given, if the employee wants to move somewhere else, may be the subject of a claim of negligence. In cases involving bad faith remedies, in misfeasance in public office, or possibly even abuse of process, or possibly breach of contract, dependent, we leave that open, may be available. But in this position, we say the position is no different to witnesses generally, or indeed people who aren't parties. In our written case, we gave the example of Mr. Kuja, who wasn't even a witness in the criminal proceedings relating to child abuse in Oxford, but who felt that his reputation was being traduced by the reporting. And of course, the actual substance of the case relates to a very different point because he was seeking an injunction restraining the press from publishing it in accordance with his Article 8 rights. But nonetheless, the point which was made by Lord Sumption, which we've cited in our written case about this is the price of open justice and the price of justice, simply illustrates the fact that this is one of the consequences of the system, and to that extent, the respondents are in no worse a position. And we ask at paragraph 67 of our speaking note, the respondents say, well, a duty of care should be owed to them because of A, the employment relationship, and B, the fact that they were accused of disreputable conduct by the claimant. But we ask rhetorically, why should their position be better than other witnesses called by the employer, who may be accused during the course of proceedings of lying or incompetence, or indeed witnesses called by the employer but not employed by him? For instance, it's not uncommon in cases involving the police for members of the public to be called to give evidence in public order cases. Equally, it's not uncommon on a Saturday night when the police are dealing with arrests. Outside nightclubs, it's not uncommon for door supervisors to become involved. And a witness who's not believed might be able to argue a different conclusion would have been reached had the employer called a number of other witnesses. Why are these, we ask rhetorically, should these respondents be in a better position? We submit they should not. In relation to privilege, on the findings of the courts below, the lawyers were retained by the appellant alone, and neither the lawyers nor the appellant undertook a responsibility to the claimants for the conduct of the litigation. And the respondents say, well, it's a situation of common interest privilege. Well, we refer at this point to Phipson, Volume 5, Tab 56, MS 1909. Phipson, at this page, addresses the question of common interest privilege. And the editors point out at paragraph 24.05, second paragraph, consideration of common interest privilege involves two separate sets of circumstances. When used as a shield, it enables party B to shield behind the privilege of party A and prevent C from obtaining documents from B, which were disclosed by A to B pursuant to a common interest between A and B in the subject matter of the communications. The expression as a shield seems apposite because the party is seeking to avoid giving disclosure on the basis of common interest privilege, since he has no independent claim for privilege in his own right. But there are a number of circumstances where a party may rely on the rights of access to documents, both privileged and unprivileged. This has sometimes been described as using common interest privilege as a sword, but in truth the cases are too varied for it to be treated as a unified principle. In such cases, A obtains from B documents for which B can withhold on grounds of privilege against the rest of the world because it is inconsistent with the relationship or common interest between A and B, for B to claim privilege against A in relation to those documents. And then they go on to refer to the fact the principle is far from homogeneous and involves a variety of situations where the courts have held the relationship as such as to allow it to be used as a sword, effectively. And the respondents here claim to seek it as a sword, arguing that by virtue of their status as employees, subject to allegations in the proceedings, they're entitled to see legal advice as of right given to their employers. Well, we submit that's a remarkable proposition, one with very far-reaching consequences, and we also submit it's wrong. Having a mere interest in the general sense in the outcome of litigation is not sufficient to give rise to a common interest. In fact, the cases tend to relate to situations where the parties have had some underlying agreement or closer relationship together. And for that, we refer to Commercial Union and Mander. Volume 3, tab 23, MS 1031. This was a decision of Mr. Justice Moore-Bick, as he then was, and the facts were it was a dispute between insurers and reinsurers. Insurers had insured the purchase of a ship against certain losses, which would be caused if the order for the ship was cancelled in certain circumstances. When the purchasers threatened to cancel the purchase of the ship because some of the defined events they said had occurred, the insurers entered into a settlement agreement with them, which resulted in funds being provided to the purchasers to complete the purchase. In other words, the insurers were seeking to nip the issue in the bud and prevent the losses from getting bigger. But the insurers then sought to pass on their loss to reinsurers with whom they had a contract. Mr. Justice Moore-Bick dismissed their claim. The reason he did so is because he held that had the reinsurers not repudiated the contract, they would have been entitled under common interest to receive them because of the contractual relationship they had. But since they had avoided the policy, they couldn't rely on some general interest to obtain the documents, and would see the holdings at paragraphs 6 on page MS 1032. A contract of insurance which contained a follow settlements clause did create a community of interest between insurer and reinsurer in the original claim. The insurers could not withhold from the reinsurers on the ground of privilege documents brought into being for the purpose of handling the original claim, even if they would be subject to legal professional privilege as against a third party. And then at subparagraph 7, as a matter of principle and authority, it was not enough that the person seeking disclosure of confidential documents could show that he had an interest in the subject matter, which would be sufficient to give rise to a common interest privilege if the documents had been disclosed to him. He had to be able to establish a right to obtain access to them by reason of a common interest in their subject matter, which existed at the time the advice was sought or the documents were obtained. And then 8, since the defendant had purported to avoid the reinsurance contract, unless the defendant was party to a contract with reinsurance with the plaintiffs, he had no relevant relationship with them and no interest in the original claim which could bring him within the ambit of the confidence or support a claim to disclosure of otherwise privileged documents relating to it. Since the defendant could not rely on the existence of the contract as providing the basis for seeking disclosure, he was not able to establish any relationship between the parties that was capable of supporting a common interest in the subject matter of the documents, and the documents were privileged. And at paragraphs, sorry, I should say it's not paragraphs, but page 1035, the very bottom of the page, on the right-hand column, at the very bottom, 1035, the judge said, although in many cases, if not most, cases in which common interest privilege can be asserted against a third party, the person to whom confidential documents have been disclosed will have had a right to obtain disclosure of them. I think counsel is right in principle to draw a distinction between circumstances which give rise to a right to obtain disclosure of confidential documents and circumstances which will enable common interest privilege to be asserted against a third party. As is apparent from the passage from Phipson cited above, it has been recognised for many years that privilege cannot be asserted in respect of confidential documents against a person who has a common interest in the subject matter of the communication. CIA, Barker and Wimpey, a case relied on by my learned friends, is one example of circumstances in which such an interest can arise. In that case, out of a contract which appears to have been in the nature of a joint venture, Mr. Howard relies on a passage from the judgment of Lord Justice Bridge, in which the principle is stated in wide terms in relation to documents brought into existence in relation to litigation in which two parties have a common interest. But the nature of the common interest that existed in that case and the circumstances in which it arose are clear from the judgment of Lord Justice Stevenson. I do not think Lord Justice Bridge was seeking to extend the principle to all cases where two parties have an interest in a more general sense in the outcome of litigation. And we say that's what's essentially been alleged here. The respondents, of course, had an interest in a general sense in the outcome of the litigation, but they had no right to see the documents which were the subject of it. And the judge pointed out at page 647, 1038, last paragraph on the right-hand side, that if the principle for which counsel contended were correct, it would, in my judgment, involve a significant extension of the grounds in which a party could claim access to documents otherwise covered by legal professional privilege. However, in my judgment, it does not represent the law. Although in many cases a relationship between two parties which supports common interest privilege will be one which also gives each of them a right to obtain disclosure of confidential documents relating to the matter in which they are both interested, one can readily think of situations in which that would not be so. Take the example given by Lord Justice Donaldson in Boots and Hammer of tenants in a block of flats. One tenant, acting entirely for his own benefit, obtains legal advice concerning a dispute with the landlord over a provision in the lease which affects other tenants in a similar way. If he chooses to give a copy of the document containing that advice in confidence to another tenant who is willing to cooperate with him in pursuing a claim, their common interest would be sufficient for the document to remain privileged in the latter's hands, in other words, as a shield. I do not, however, see any basis upon which the second tenant could have insisted on seeing the advice if the first tenant did not wish to show it to him, even though they had a common interest in the subject matter. Both as a matter of principle and authority, I think counsel is right in saying that it is not enough that the person seeking disclosure of confidential documents can show that he has an interest in the subject matter, which would be sufficient to give rise to common interest privilege if the documents had been disclosed to him. He must be able to establish a right to obtain access to them by reason of a common interest which existed at the time the advice was sought. So what we say here is that, of course, any confidential material that Mr. Johnson or the solicitors would have shared with the respondents at a conference they attended would have been privileged as against the rest of the world. And to that extent, the common interest privilege would have existed between the respondents and the appellant. But that is not the same as saying that the respondents have a right to seek disclosure of privileged material themselves as against the appellant. As I say, if they did, it would have far-reaching consequences for litigation conducted by employers. And of course, it would have, to defend this case, or indeed any similar case, an employer would have to consider waiving privilege, which will tend to undermine the privilege itself, because the whole point of the privilege is that people should be able to speak frankly to their lawyers about concerns they have about the case, including in the case of an employer, to be able to speak frankly to their lawyers about concerns they may have about their key witnesses against whom allegations are made, to speak frankly about other circumstances where complaints may have been made against those witnesses, so that the employer and the employer's lawyers can then decide what needs to be disclosed to the other side and to the court.
I mean, this is the Medcalf and Wedrell point.
Yes.
Yeah.
Essentially, to require that to happen may result, and is likely to result in employers, if they know that what they say is going to be read later or may be read later by their employees, being much more circumspect in what they're prepared to say. And we will endeavour to get Metcalfe to the court.
Well, it doesn't take a lot of imagination to think what sort of a conversation was going on 2 days into this trial.
Quite. Yes. But it's important that employers shouldn't face those matters being sort of publicly aired, which may in itself,
argument, obviously.
which may in itself cause the employee to think that their trust and confidence has been undermined. My lady, I've gone slightly over 3 hours, but those essentially are our submissions. And for the reasons we've given orally and those set out in our case, we respectfully invite this court to allow the appeal.
Thank you, Mr. Warnock. I think we've asked you all the questions we wanted to. Ms. Dobby, do you wish to follow?
I don't have anything to add, my lady.
Thank you. Mr. Bowen.
May it please you, my lord, my ladies. I have a speaking note. It's a little longer than my learned friends. Unfortunately, I can't give it to you at this minute. I will email it this evening as soon as we can. The reason is, of course, that we couldn't anticipate everything my learned friend was going to say, so it's not in a state at the moment to hand up to you. I'll go through various references and everything. They'll all be in the note for your convenience. I'm just going to start by setting out my structure and make some short headline submissions and give you my propositions. We have identified, as you will know already from the written case, MS65 bound volume, the two major issues at paragraph 4. Our contention is that the claim duty is simply a manifestation of the long-established term of trust and confidence implied into every contract of employment. If we're right about that, we say no scope or need to conduct the policy-led incremental approach under Caparo, i.e. the fair, just and reasonable approach. That's issue 1. So that's we're in it already. The terrain has been recognised. Secondly, our second issue, in the alternative, it would be fair, just and reasonable for such an implied term, stroke the mirror duty of care, to be recognised. So that's the overall position. And as is inevitable in these cases, we have refined that further, issue 1 into 3 separate propositions, and then issue 2 into a further 2. So we've got 5 headline propositions. Unfortunately, we've had to split the 5th proposition into a further 7 sub-propositions, because that's all the policy, that's the various conflict, contribution, the points that we've picked up and responded to from Mr. Warnock. Now, I will then, before I get into covering those propositions, just say a few words on assuming that we are within scope of the term and that the term then reflects the mirror position in terms of the law of tort. I will say clearly on the facts, first of all, this was a case where there was a sufficient trust-destructive course of conduct. So there was a sufficiently destructive behaviour by the employer here, the chief constable, or rather the commissioner, to destroy trust and confidence. And secondly, and something that we haven't really zoned in on very much thus far, that as will very frequently be the case, in this case, on these facts, there was no reasonable or proper cause to excuse or justify that.
Well, how can we go into either of those points? They're both highly factual points. We're dealing with effectively a strikeout. we aren't here to express views on who's going to win the action if you've got a potential cause of action.
I'll take them quickly.
Well, I don't see what the point of taking them is, for my part. I mean,
Well, I'll just move to my first issue, Proposition 1. We say, first proposition, and I'm just going to rattle through these, so and try not to expand them in any way, at least at this stage. The established term of trust and confidence is well established. It's a broad term, a portmanteau term, to use the phrase of Lord Nichols in Malik. It requires the employer to refrain from behaviour without reasonable and proper cause, which is liable to destroy or seriously damage the relationship of trust and confidence that lies at the heart of the relationship between the appellant and the respondent. So that's
And it requires the employee to do the same.
yes,
It's a mutual
yeah.
obligation.
You've got the mirror. The employee has a duty of fidelity and good faith, and this is the converse position upon the employer. Our second proposition is that the broad term includes the postulated duty. The term is implied by law, that's clear on the authorities, into every employment contract. We say it encompasses the postulated duty, namely such trust-destructive conduct by an employer in the conduct of litigation. So there's no magic about the terrain, the specific terrain of, just because we're talking here about the conduct of litigation. Proposition 3, so the final proposition of issue 1, if the postulated duty is within the scope of the term, and therefore our postulated duty by sort of the mirror analogy, there's no room then for the fair, just and reasonable assessment, a sufficiently recognised category. I think, to use Lord Toulson's phrase in Michael, you look at where the law has ventured, where it's gone, and where it hasn't gone. And we say that although subject actually to the Singh case, which I've not seen before and we haven't really had a chance to think about yet, paragraph 19, it seems maybe that the law is certainly creeping towards that area, if it hasn't been there at all in terms of specifically litigation. But we say that when you look at the cases, particularly the cases at paragraph 14, it's a category where we can fit within the category that has already been recognised. Issue 2. So these are now my two sub-issues under issue 2. Proposition 4, if you reject our first non-caparo approach, a small step, not a giant leap. So if the postulated duty is not within the trust and confidence terms express scope, it's a very small incremental step or expansion to get there. And then proposition 5, and there's obviously much more content in relation to this. In short, the policy concerns support the duty. So we say it would be fair, just and reasonable to make that small step, because the policy reasons supporting that small incremental step far outweigh any countervailing factors, some of which, or many of which, we acknowledge. And I'll be coming to that in due course, probably though, not I suspect until tomorrow. And they are, of course, and Mr. Warnock has, in terms of his oral submissions, has reordered them slightly from the way he put them on paper. We have responded, and I'm going to respond orally to the structure in the written case. So the first is conflict. Possibility of a conflict emerging between the parties, we say, is not a sufficient reason to deny the postulated duty. The second, the legislative scheme under the Civil Liability Contribution Act, 1978, does not run contrary to the claimed duty. Thirdly, an important one for us, reputational damage. The extent of the actual or potential reputational damage to the respondents on these facts and parties in their position points strongly towards a recognition of the duty.
In how many circumstances is there a duty to avoid causing reputational damage to people other than the law of defamation?
Well, the answer to that is in spring.
Well, yes, but that's all part of the employment relationship, isn't it?
Well, no.
Spring was an assumption of liability, wasn't it?
It is recognisable. If you take a Caparo approach, because of course
I'm just asking you a perfectly straightforward question about the existing state of the law. In what circumstances does anybody owe any obligation to anybody else not to damage their reputation? Now, the law of defamation is an obvious instance, but how many more are there? Spring, we know, the employer who gives the damaging reference, but...
There's spring, and then it is accepted, for instance, in Malik, that a breach of the implied term of trust and confidence can protect reputational damage. Mm-hmm. I mean, I'll come to that as part. It'll be in my speaking note, and I'll come to that in due course.
Yes, but anything outside that? Anything in the law of tort, as opposed to in the law of the employment relationship?
Well, we've pointed to the implied term. We've pointed to defamation. I suppose malicious falsehood. There are
malicious falsehood. Well, you may like to think about it.
We'll think about that over. We'll think about that overnight.
I am asking, to what extent is there a duty to avoid reputational damage to anybody?
Well, as you can see, our entry point has been through the Malik term, the trust and confidence term inspired, or rather the duty of care that Lord Justice Moore Britbick recognised as a result of
yes,
the
but
fact that
you're now out of that because you're into your second.
Yeah. We'll come back to that. If there is an answer other than spring, defamation, malicious falsehood, we'll try and find it and we'll come back to it tomorrow. So my fourth sub-proposition under Proposition 5 is that there are, in fact, contrary to what Mr. Warnock says, no insurmountable practical issues or problems which arise from our postulated duty. That then takes me on to the fifth sub-proposition, legal professional privilege. We say that LPP issues do not operate to militate against the recognition of our, now under this head, expanded duty. As here we say there was plainly a joint or common interest between the parties. Whether or not there is or is not a joint or common interest is not purely a legal question. It is also a very fact-sensitive question. And it will, I'm sure, not have escaped your lordships, your ladies' attention that part of the case was adjourned from the very beginning. So Mr. Beggs, when he argued it at first instance, didn't pursue that part of the strikeout. What they were doing was they were trying to strike out significant elements of the case on the basis of LPP. We never got there because Mr. Justice Jay said, we don't need to look at that, we'll look at the principal point on duty first. And that remained...
Are you saying that you were asking for documents and the defence was privilege and that was, as it were, put off? Or are you saying that even in this argument about whether there's a duty of care, somehow the concept of legal professional privilege was put to one side?
Yeah, the way it emerged was we pleaded it by reference to steps taken within the litigation, what happened at the conference, subsequent failures in relation to the loss of evidence, etc. And the answer to that came coming back in the defence, although it was a bit of a curate's egg. The parts that did not suit the Commissioner were said to be subject to LPP, and accordingly they wanted to strike it out. Had the case proceeded, we would have wanted disclosure of various documents. We didn't get into that because the judge decided not to deal with it.
That's rather what I inferred from your comment, but I don't think it means we can simply ignore the question of legal professional privilege in our consideration of whether there's a duty in the first place.
I think that's right on a macro level, absolutely, which is where we are. But as long as the point really that we seek to drive home is that it's not such a clear policy point that it can be taken into account in terms of a real countervailing principle against the imposition of a duty, because every case will be different. And when one looks through all of the LPP cases, Mander, Barker, and all of the others in the bundle, you will see that an awful lot depends upon the facts, whether there's a contractual relationship with express terms giving access to documents. It's all quite a complicated position, and it doesn't provide an answer. I'm going on.
Personally, I mean, I just looked at the defence and I see that the issue which the judge presumably wasn't prepared to deal with is your attempt to rely, according to the defendants, on documents, correspondence, advice and privilege and discussions that attract legal professional privilege. And they say that parts of your statement of claims should be struck out because you're seeking to rely on privileged documents to establish the existence and breach of a duty of care, which one can understand why that might have been shelved off as irrelevant to the present issue. But the present, if we're concerned with the present issue, what special facts are there which create any problem or which could impact on common interest privilege so as to give rise to a duty to disclose? What are you suggesting?
Sorry, I'm not sure I followed that.
We've got a relationship. We know these are officers, the Met. But we know that a claim was made against the Met, and we know that presumably they instructed solicitors and took legal advice. What special facts are you suggesting which create a situation where they're obliged to disclose their privileged documents to you willy-nilly?
Well, the special facts are, the answer I think is the special facts, and we'll see this when we get into the explanation of when a joint or common interest applies, is if you have a joint or common interest, there is no LPP. You can't rely on it.
Yes, but
you can't rely on it in between employer and employee.
Well, it appears from the decision we were shown a moment ago that the judge there accepted a distinction between situations where the documents were actually disclosed to someone with a common interest, whereupon, of course, there's no privilege between them, there may be against a third party, and situations where they haven't been disclosed by A to B, and B can't get them. Even though if they had been disclosed, there would have been a common interest against third parties. So, having got that distinction, what I don't at the moment see is what special features of your client's relationship with the Met give you a right to say that you can claim the documents.
The special feature here is that there is a contractual position or a quasi-contractual position between the officers and the Commissioner. They had a unity of interest. I mean, I don't want to get too drawn into this at this stage because this is a separate part of my policy arguments, and I understand entirely Lord Mance's desire to sort of pin me down on this at this stage. But could I deal with it when I get to it in order, as per my speaking note, for fear that I give you the wrong answer? But our basic point is that if you have a common interest privilege, then they can't rely on LPP. Now, at the moment, if that's not satisfying the court, then we'll think about it overnight and come back and look at that tomorrow in order of my propositions. I think the sixth sub-proposition, which I don't know whether my learned friend is abandoning this or not, but we plan to say a little bit on distributive justice, because he says the recognition of the duty would offend against the principles of distributive justice. I think that one is in relation to there being a differential between witnesses and these particular categories of this particular category of witness, i.e. police officers. And then finally, we'll look at the protection for litigants who act in good faith. And the proposition there is that the claim duty does not run contrary to any jurisprudence concerning liability for the conduct of civil proceedings. So those are our propositions. I'll now say a little bit, not too much about the facts. So the arrest was on the 2nd of December 2003. It was part of a complex intelligence-led operation. It was a joint operation between the Metropolitan Police and MI5. It took place at a time when the threat of terrorism post 9/11 was acute. It was 11 months after a similar terrorist suspect, Mr. Carmel Burgas, had resisted arrest and had murdered a police officer called Stephen Oak. That had happened in January 2011. And as a result of that background, plus the specific background in relation to the large operation, the arrest of the forced entry into Mr. Ahmed's house was only part of, I think, 15 or so separate events which happened on the same day. So they raided cars, they raided various addresses, and they did not know what they were going to find. So this is all in the papers. So the officers were briefed by the management to utilize a strategy that the MPS called deck and dominate, subsequently described, I think, by the Met themselves as unfortunate language. There's a reference there in the particulars of claim is at MS 151, admitted at MS 192. So that's paragraph 4, subparagraph 8 of the particulars of claim and 12B of the defence. So they were told that Mr. Ahmed was an expert in armed and unarmed combat, to be treated as extremely dangerous. They were warned that the property might be rigged with explosives. That's paragraph 3 to 5 of the pleading, MS 151 to 152. They give their account of the struggle that led to his arrest. He resisted arrest on their case at paragraph 7 to 9 of the pleading, MS 152. Mr. Ahmed's contrary account, you will see set out in his subsequent civil claim. That's his pleading, paragraph 2, MS 321 to 325. And he alleges a fairly gruesome, or a very gruesome mix of gratuitous violence, racial abuse, religious abuse, sexual humiliation as well. One of the officers allegedly started to manipulate his testicles. He claims at all stages he was completely compliant. That's MS 321 through to 325. And we observe, as we've observed in the written case, that if true, these allegations would have justified suspension, disciplinary proceedings for sure, and very probably sacking, removal from the police force. Now, 2 days after the arrest, the next day, following a complaint. So Mr. Ahmed makes his first complaint on the 3rd of December, and the complaint goes to the conduct of the arrest and also the transfer of Mr. Ahmed to the police station. There were exhaustive investigations into what occurred. First of all, by the Police Complaints Authority, that's the predecessor of the IPCC. I think what happened was that the PCA sent it back to the MPS for an internal investigation. Then, a little later, when the PCA became the IPCC, it was then I think a managed investigation, an independent investigation, that was carried out. It went to the Crown prosecution twice, and on both occasions it was decided that there was no sufficient evidence to prosecute any of the officers. And you find all of that at MS 153 to 156, paragraph 16 to 33. Now, broadly speaking, 2003 through to 2004 is when all of that happened. So the result was that the second, the third, and the fourth claimant officers, so that's Cowley, Donoghue, and Jones, they are all completely exonerated. The first claimant, Mr. James-Bowen, he was exonerated by the initial internal inquiry completely, but when the IPCC looked at it, they decided that it was sensible to, or necessary rather, to recommend disciplinary proceedings in relation to the initial contact. That's when he comes into the room. His case is that Mr. Ahmed struck what's called a fighting stance, and he charged at him, and they ended up smashed against a window, the window frame. And during the fight, he tried to go for a ceremonial sword. So there's a lot of factual debate about that. It goes to the disciplinary board. Particulars of claim, paragraphs 24 and 27, MS 154 to 155. You'll also find it in part reflected in the Statement of Facts and Issues at paragraph 4, MS 34. So what happened after that, and this is April 2005, there's then a 3-day hearing, SFI paragraph 5. First claimant, again, exonerated. Paragraph 32 of the Particulars of Claim, MS 156. Chair of the panel saying at the end that he should have been commended for his bravery, not castigated or disciplined. And the finding was that the force he used in the initial contact was agreed to be reasonable. All of that was entirely adopted by the employer. To compound the very unpleasant experience thus far, in early 2005, the names of all the officers are released in error. They should have been confidential. So they are then identified, and they're identified by reason of an error. You find it at paragraph 6 of the SFI, and also MS 291 to 292. There's some suggestion that it was the fault of the IPCC rather than the appellant, but I think there was no conclusion as to who was actually responsible or whether it was a question of joint responsibility. But whoever's error it was, the appellant, the commissioner, apologised, and then various security measures were put in place because there was a very, very genuine concern about the safety, the physical safety and the threats to life, not only of the officers but also their families. The precautions were necessary due to what was being said publicly. Blood-curdling messages of hate were posted on one particular website by supporters. It was called Free Baba Ahmed. They were identified, and there was one particular posting saying, "I'll pay for their destruction. I'll pray Allah will remove their senses. We'll get their daughters raped and their sons paralysed. MS 293, third paragraph. And that was, I mean, that's been common ground throughout the throughout this litigation. Then the next significant step, 18th of October 2007, Mr. Ahmed issues his civil claim against the appellant, SFI paragraph 7, and then you find his pleading at MS 321 through to 328. Just as a matter of detail, it had been previously issued. When you look at the facts, you'll see it had been previously issued on the 26th of June 2005, but there'd been a failure to prosecute it by his previous solicitors. So there was a 2-year gap, and then then the litigation kicks off. At that stage, these officers say there was a positive decision taken to defend them. It wasn't a question of not being sure in any way about their account. They were given, and I'm not going into assumption of responsibility, I'm not trying to reopen parts of the argument that we've lost, but as in terms of the background to what remains relevant in this case, it was clear that at that stage a decision was taken to defend. They had or should have had access to all of the evidence. But subsequently, in the 14 or 15 months that elapsed between the issue in October 2007 and the trial in 2009, there were a litany of delays and failures, a failure broadly to prepare the defence. And it's pleaded that the cause of that was an understanding or a belief by the Commissioner and the relevant senior officers that it was inevitable that Mr. Ahmed would be extradited to America. And there was a lot of ongoing proceedings about that, which I think took a very long time and ultimately ended up in the European Court of Human Rights. And or that the case would settle. On the 19th of February, and you'll find all of this is in the pleading. On the 19th of February 2009, so barely a month, I think about 3.5 weeks before the first day of the trial, there is a meeting. And at that meeting, the officers are told for the first time that Mr. Ahmed has rejected the various offers that were made, that the legal team were now, quote, rushing to prepare the defence, that evidential difficulties had emerged, including new medical evidence from Mr. Ahmed. At that stage, it becomes clear that that medical evidence can't be answered because the Commissioner has not instructed an expert of their own, and you'll see all that in the core volume, paragraph 53 of the particulars of claim at MS 161. So, the case is then listed on the 16th of March. There are 2 days, I think, of preliminary argument, and it settles on day 3, the 18th of March, and it settles with costs and a public admission. That public admission you see in the pleading at MS 169. If I just read that out to you, turn that up. It's paragraph 82. I mean, I'm not going to take you to the individual acts that they were said to have committed, all of which were admitted bar the first one. But when you see those, you'll see that they are a very serious list of effectively criminal offences. But in addition to that admission of liability, a press release was issued by the Commissioner's office, which read, for offer, the Commissioner has demanded an immediate investigation into the circumstances surrounding the officer's refusal to give evidence relating to this arrest in 2003. Whilst the arrest and subsequent events are historic, this is a serious matter which has been referred to the IPCC.
I thought you were going to show us the admission. That seems to be a comment on the admission.
Sorry, that is, well, that's, bear with me. The admission is the defence is at it's MS 209 to 2010. So you see paragraph 64, page MS 209, admitted that the defendant made an admission of liability and consent order, which accepted all bar one of Mr. Ahmed's pleaded allegations against the defendant. B, it's admitted that a press release was issued by the defendant's office and that its contents are pleaded accurately at paragraph 82. No admissions are made as to whether the defendant was endorsing the claimant's guilt by making the admission, whether when read with the press release or at all. It's not admitted that the defendant's predecessor, Sir Paul Stevenson, ever made a public utterance that BA had been a victim of gratuitous violence. But when you look at the consent order, the liability, and what they were actually admitting, stamping on his feet, causing him extreme pain by manipulating the handcuffs, all sorts of very nasty and unnecessary examples of unreasonable force.
Obviously, we're looking basically at the statement of facts and issues, and arguably, my lady has been very indulgent in to you in letting you expand so much.
Right, okay.
Absolutely.
I'm looking at paragraph 16
Yeah.
of the statement of facts and issues, where it is said by both of you that the appellant settled BA's claim and admitted all but one of the 21 allegations and apologised for the gratuitous violence. And I think it was that part of the apology that Lord Mance might have been hunting for 2 minutes ago. Where do we get an apology for gratuitous violence?
Exactly.
So where do you get the apology, did you say?
Yeah.
Well, I've been listening to Mr. Bowen.
it's-
He has been reciting the particulars of claim. And
Well, this is a statement of facts and issues
yes,
that,
but
that
what
Mr.
I'm
Warnock
getting
signed.
what I'm getting at is the particulars of claim are not part of the agreed factual
Of course they're
matrix
not.
for this
But-
case, which
but
I
this
wish to make
apparently-
clear to everybody.
Right.
Well,
But this apparently is agreed. Apologise for the gratuitous violence, and one would be interested to see the actual terms used.
well, unfortunately, I mean, when this case was pleaded now a long time ago,
Yes.
I said I wanted to see the press release. Nobody can find the press release. We've searched digitally for the press release. The police haven't produced the press release. Who knows, it may turn up. But at the moment, the best we can do is the content of paragraph 82 and the admissions. But despite the fact that it is there's a non-admission there at 64E, the position I take your Lordship's point does appear to have changed in that it's been admitted. So really, I'm wasting a few minutes of your time going through that on one level. But the officers certainly are extremely keen, they're all in court, that they're extremely keen that you really appreciate and take on board precisely the graphic nature of what they are said to have done to a man who was allegedly absolutely compliant and peaceful.
Well, rightly or wrongly, appropriately or inappropriately, you've done a good job in that,
thank you very much.
in
I'll
that
move
regard,
on.
Mr. Bowen.
I will move on. I will.
Well, 64, something you referred to a moment ago, paragraph, I'm not, could you just tell me the E number? Sorry, the MS number.
Okay. So, now, where will I?
Maybe it's 210, I think.
Sorry, could you just repeat that question?
No, I've got it.
Got it, right, thank you.
64E is page 210. The answer is the phrase gratuitous violence comes from the defence, where no admissions are made as to the gratuitous violence.
Yeah.
And then you picked it up in the statement of facts and issues between you.
Right. So my next point is the apology was in complete contrast to the conclusions of the internal and the independent investigations. It was embodied into the consent order, which you see at MS 359. If you just turn that up, you'll see there, actually we don't get a huge amount more from it. You can see judgment of the claimant. So he was paid £60,000 plus costs of about £240,000. And the relevant part of the first two lines, or the third and fourth line, and upon the defendant having admitted the allegations set out at paragraphs 2A, B, C, and E to V, inclusive of the attached particulars of claim.
Well, if one's looking at the facts, I mean, the Met was in a slight corner, wasn't it? Because your clients weren't willing to give evidence. They had applied unsuccessfully for special measures, and so one must assume that they were wrong on that issue, that the court correctly decided, mustn't one, that they weren't entitled to special measures, and yet they then said, we won't give evidence. So the Met was in a bit of a corner.
Not that straightforward.
No.
And absolutely not that straightforward. First of all, there was an agreement, rather oddly in this case, relied upon by Mr. Warnock's client as a aspect of a contributory negligence claim, saying, well, we couldn't actually subpoena you to give evidence because you had agreed with us that in the absence of special measures, you wouldn't give evidence. And what actually happened was they said, we want special measures. This is the first, this is the conference, the second conference. The first conference was with lawyers and counsel for the police alone. The second, on the 18th of March 2008, was with 3 of the 4 officers. There they have the discussion which is relied upon to show we are not going to give any money to an alleged terrorist. Do not worry, we will look after you. We will act for you effectively. That agreement was understood to be the case on the basis that they would then properly garner the evidence. It wasn't until 4 weeks before the trial that they realized that the ship was sinking, that they were told that it was going to be impossible really to properly defend the claim. The position of the officers then was not that they would not give evidence, it was that they would not voluntarily give evidence, understanding that it was possible that they may yet still be the subject of a witness summons. And because they realized that, and they realized it was part and parcel of their public duty to give evidence, they all assembled at Paddington Green Police Station on day 1 of the trial, and they waited. And there were numerous emails and communications between the officers and the management about what was going to happen. They were there waiting, and there were meetings of the Gold Group, 2 meetings of the Gold Group. We don't know what happened because it's said to be subject to LPP, and a decision was taken by the police not to call them. So they didn't refuse to give evidence. They just said, we are very unhappy about giving evidence in circumstances where we have been advised both internally, this is all in the pleading, by a chap called DS Nick Westwood, who said, if I were you, I wouldn't give evidence because there's a danger that if you do give evidence and a finding is made against you, you will be taken out of what they call the evidential chain. And that means, if you're taken out of the evidential chain, it means that because a judge has made a finding of fact that goes to your credibility, you will never be able to be an operational officer again because you won't be able to give evidence. Because the first question defense counsel will ask is, or it'll be put to them, that they have been found to be lying in the Ahmed case. So the stakes for these young, ambitious professional officers could not have been higher. So you have internal advice being given, you're damned if you do, you're damned if you don't, and you then have external advice given by the Federation, who came on board, you'll have read from the SFI, Russell, Jones and Walker. They came and they advised specifically they had been involved in relation to the release of the identity point, the IPCC, And the advice that was given by them was, well, you're now in an extremely difficult position because because the defence hasn't been properly prepared. If you go in and you give evidence, there's no corroboration. If you decide not to give evidence, then, and the case proceeds, there is still the danger of adverse findings. So you are now in a really, really tough spot. They were just 3 or 4 ordinary police officers, and the position that they were in was described by Mr. Justice Jay as a complete imbroglio, if indeed, of course, the facts are true and can be established at a trial. So if ever there was a case, we say, of a destruction of trust and confidence as a result of a complete failure to behave as a normal, responsible employer, we say this is it. So there's a classic employment case in that sense. So I've done the consent order. The admissions, we say, were causally linked to the subsequent decision to prosecute the 4 officers who stood trial then at Southwark Crown Court for 4 weeks. I can't give you the precise timeline, but it's in the chronology in the SFI. So a year or so later, from memory, they stand trial. It takes a month. The jury take 15 minutes to acquit them. And the foreman of the jury says in open court to the judge that the jurymen and jurywomen wanted to shake the officers' hands before they left court. So we say, and it may well be that, certainly from what Lord Mance said to me earlier on, that the next part of my argument you don't want to hear, but if you just bear with me, I'll set it out, and if you tell me it's not material, I will abandon it. We say that all of that establishes intolerable conduct and therefore is within the scope of the trust and confidence term and incorporated into the postulated duty. We say intolerable, unnecessary, unfair. They had a very detailed IPCC report that set out all of the evidential and factual background where in relation to the multiple failures of preparing the case. The failures are summarised in the following locations. I'll just give you the MS numbers. By Lord Justice Moore-Bick at paragraph 39, MS 106. In the SFI at paragraph 27, MS 40. And full details, very full details set out in the pleading. Paragraph 111, Roman 1 to Roman 3, MS 177 to 180, and also see MS 293, last 3 paragraphs, over to MS 295. So all of that material shows really obvious delay in taking sufficiently timely steps and leaving crucial decisions and crucial searching for evidence until very, very close to the trial date, 3.5 weeks. The medical evidence point I've made. There was another point in relation to why they hadn't instructed an expert on use of force. Such an expert had been suggested at the conference on the 18th of March by the officers, because there are all sorts of internal documents about this, about how you should go about restraining somebody. Such an expert was called in the criminal proceedings and probably must have contributed to the rapid verdict of not guilty. There was a general failure to identify and retain evidence, in particularly to find the probe. The probe, of course, being this entire event inside the house was recorded. It was recorded by a listening device that was set out in his prayer room, and or that was inserted in his prayer room, and
Mr. Bowen, I don't really want to stop you doing this, Because I understand you're representing clients who are here who want to hear all of this.
I'm almost done.
But frankly,
Yeah, okay.
the question for us is a pure question of law,
Yeah.
whether in certain circumstances a duty of care exists. The allegations as to how that duty of care, should it exist, have been breached are irrelevant.
Yeah. I'm there now. I'm saying no more about that. Just under the heading no reasonable or proper cause, we say there was no justification for the behaviour. And this, I hope, may help you. A possible reasonable and proper cause might have been, and this is a point that your ladyship made yourself earlier on, a failure by the officers to cooperate, which disabled the commissioner's ability to defend the case. A belief that the officers had abused their position and that there was truth in the allegations. That's another possibility we've thought of. Thirdly, there had been concluded or ongoing disciplinary processes, or new evidence had emerged. So none of that applies in this case. So that takes me to issue 1 and our first proposition. And we say the existence of the trust and confidence term is not in doubt. The content is clear. It's been set out, and my learned friend's taken you to Lord Nichols in the Eastwood case. 522E, and there he sets it out, volume 3, tab 27, MS 1111.
Sorry, which volume, please?
Volume 3.
Thank you.
And it's at E. The developed formulation of this duty became, so far as the employer is concerned, a duty that an employer will not, without reasonable and proper cause, conduct himself in a manner likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. And then the history is all set out at paragraph 5 onwards of the Eastwood case. And the sort of saving words, the justification wrapped up in reasonable and proper cause means that even if objectively the behaviour was dreadful and had a real effect on the reputational impact on the employee, stroke the officers, assuming that there was some form of reasonable and proper cause, there is no breach of the implied term, and therefore there would be no breach of any mirror duty that we seek to impose in the law of tort. Now, the history of how the law reached this position is in our written case at paragraph 11, MS 67 to 68. It started life as a response to the inadequacy of the law, which failed to protect employees when they were unfairly dismissed. You then had the Donovan Report in 1968. As a result of the Donovan Report, the Industrial Relations Act 1971 was introduced. That brought in statutory remedies which only applied if the employee could show a dismissal and not where an unscrupulous employer very badly enforced an employee out. So those are the constructive dismissal cases, what are referred to as squeezing out. To show constructive dismissal under the 1971 Act, you had to show a fundamental breach or a repudiation of the contract. That's the Western Excavating v. Sharp case, 1978 QB 761, which we don't have in the bundle. Further history all set out, 4 to 6 of the Eastwood case. You've already got the reference, MS 1111. But then, as Lord Nichols summarises at 522B to G, the flexibility of the common law then came in to provide the remedy that became known as the trust and confidence term. It's not the first. The first time, I think, is a case called Courtaulds, which Milady, as you then were, Lady Justice Hale, I think, in Gogay gives us the history. It was Mr. Justice Arnold. But the example he gives is the Woods case, Woods against WM Car Services. And we got the Woods case at volume 5. Could I just ask you to turn that up? Tab 48, MS 171717. And I'm going to read from 67G.
He did. It's
Sorry,
tab 48 in front.
Tab 48. So 670G to 671B. It's just a short passage. In our view, it's clearly established that
You better give the memory stick numbers too.
I'm sorry.
1721 to 2, isn't it?
1721.
Yeah.
1721. So, in our view, it's clearly established that there is implied in a contract of employment a term that the employers will not, without reasonable and proper cause, conduct themselves in a manner calculated or likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. There's the first case, in fact, Courtaulds against Andrew. To constitute a breach of this implied term, it is not necessary to show that the employer intended any repudiation of the contract. The tribunal's function is to look at the employer's conduct as a whole and determine whether it is such that its effect, judged reasonably and sensibly, is such that the employee cannot be expected to put up with it. See British Aircraft Corporation against Austin, and another case, Post Office against Roberts. The conduct of the parties has to be looked at as a whole, and its cumulative impact assessed. We regard this implied term as one of great importance in good industrial relations. Quite apart from the inherent desirability of requiring both employer and employee to behave in the way required by such a term, there is a more technical reason for its importance, and then they go into the bowels of the statute and the difference between, I think, dismissal and the problems relating to constructive dismissal, which I needn't, unless you want me to, go into. So it is now a standard term. It's been called a default term, and it's imported by law into every contract of employment. Now, at paragraph 14 of our written case, that's MS 69, we take 7 cases, we give 7 examples. The way that we came by these 7 examples is if you look, just so I can, so you know it exists in the bundle. The 32nd edition of Chitty on Contracts, you find at Authorities Volume 5, MS 1798, onto, it's a fairly short passage, but very detailed, to 1804. And there you have the trust and confidence term set out, as I have quickly summarised, and my learned friend as well, how it's been extended and further applications and extensions of the implied obligation of trust and confidence. And in the footnotes, there are endless cases referred to. And what we went through the process of going through those, and we derived from that, just as the best examples that we could see, Gogay, Eastwood, McCabe, Deadman, Yap, Stevens, and Braganza. And we say that those cases illustrate what we say is the proper approach to a case like ours, even though it involves the conduct of litigation. Those cases illustrate that the courts, applying the well-known portmanteau term, are prepared to apply it to different sets of facts in diverse circumstances. We say that the courts look, one, at the conduct itself, and is it sufficient to clear the high bar, what I think Milady called a severe test, I think were your words, from memory in the Gogay case, to establish that the term is engaged, or, because here we are in tort land, not, or quasi-contract land, breach of the duty. And secondly, is there a defence based upon reasonable and proper cause? Now, in none of those cases was a Caparo analysis carried out. And that's the point we make at paragraph 15 of the written case, MS 69 through to 70. Now, what my learned friend has sought to, without taking you in any way to the facts of those cases, bar I think he took you a little bit to Eastwood, he dismissed them all as being cases about malice, about bad faith. Well, that with respect is plainly not correct. Could I give you the references to where you'll find all of these cases?
We've got them, haven't we? We've got in the margin.
Have you got them all? Right, okay. Well, you'll have them in the speaking note as well when it comes in. But if I take Gogay first, Gogay Volume 3, tab 31, MS 1209. So this involved a very disturbed child who'd been sexually abused by her father, associated care and attention with sexual contact, and it became of great concern to a woman called Julie Gogay, who was the residential care worker, that the child was becoming obsessed with her, sought her out, and was beginning to behave in a rather sexually provocative way in her presence. So Miss Gogay asked not to be left alone with the child and reported all of her concerns to the employer. She said she found it very worrying. She took 10 days off as a result of stress. She was supported by the management. They complimented her on her professionalism. It confirmed that no allegations had been made against her. However, in subsequent therapy sessions, the child began to talk about Gogay in a way which triggered a Section 47 investigation under the Children Act, as a result of which she was suspended pending the outcome of the investigations. And she discovered this not by being invited to a meeting and being told in what was happening, but just by a letter informing her of the suspension, and that it was on account of an investigation into an allegation of sexual abuse, that's a quote, by a child in her care. She was traumatized as a result. It transpired after the investigation that the child had in fact never said anything in the therapy session that could be construed as an allegation of sexual abuse. She was then reinstated, but she couldn't return to work as she developed clinical depression brought about by the suspension. So those are the facts of Gogay. And then the judgment of Her Ladyship, term of trust and confidence restated with reference to Malik, that's MS 1215, paragraph 53, and I won't take you to that. That's pretty much a repetition of what we've already looked at. The judgment also confirmed that the test as to whether the conduct had breached the term is a severe one, and that the accusation that somebody had perpetrated sexual abuse met the threshold. That you see at paragraph 55. Second line test is a severe one, and 4 or 5 lines up from the bottom, to be accused of it is also a serious matter, etc. The question, therefore, is whether there was reasonable and proper cause to do this. And then, having established the severity of the conduct, the question Oh, well, sorry, I made that point. The question at paragraph 55, was there justification? And then in the result, paragraph 59, the court ultimately held that the suspension of the claimant was a knee-jerk reaction that breached the implied term, whilst at the same time making an important point about conflict, which we'll come to tomorrow, at paragraph 59. And there, Your Ladyship said, nor should there be any doubt that if there is a conflict between the interests of the child in their care and the interests of an employee, the interests of the child should prevail, but the employee is entitled to something better than the knee-jerk reaction which occurred in this case.
I mean, I don't recall Mr. Warnock actually saying that all these cases were explicable on the basis you suggested a moment ago. And indeed, if you look at his written case, he doesn't say that. He distinguishes Malik Eastwood from the present case, where he says there was positive action by an employer directed to the very continuance in the employment relationship. I don't recall. I think it appeared very difficult.
That was my understanding of what he said when he referred to the cases in paragraph 14, but if I got that wrong.
No, he was saying that some of them were to do with actions by the employer which are directed at terminating or suspending the employment relationship.
Yeah, and he talked in terms of bad faith, particularly I think...
but not those actions.
Not those. That's different cases. If you look at his written case, he distinguishes the cases of bad faith from these cases by name.
And I think, in fact, it was Eastwood, the next case, that he referred to as a case which was really akin to malice. And the facts of that were, and this is volume 3, tab 27, MS 1092, so this is another of our cases. So there, the facts were just very briefly, the claimants, he was a worker in the security section of the Magnox power station in Anglesey, sought damages for a stress-related illness and an inability to work caused by a campaign by the employer to demoralise him or prior to dismissing him. The alleged demoralising conduct arose as the result of a long-standing grudge held against Eastwood by his manager. And the conduct included an inquiry into employee relations in the security section, but the real purpose was to seek information adverse to him, encouraging other employees to make complaints and beef up complaints against him, suspending him publicly on the grounds of sexual harassment, culminating in disciplinary proceedings, by which time, well, in fact, I got both men here. I think there were two of them. Yeah, sorry, Eastwood and another. They were already suffering from depressive illnesses, and then they were ultimately dismissed. So they took the employer to the tribunal, pursued unfair dismissal proceedings. They were compromised. They resulted in financial payments, but the agreement preserved the right to go for wrongful dismissal and a common law claim. And then just explaining what happened there after the proceedings, the claim was struck out at first instance on the basis that it was within the Johnson and Eunice exclusion zone, and that, I think Mr. Warnock made this point, came up against the buffers, as it were, of the unfair dismissal legislation. That's 526D, MS 115, and that was upheld by the Court of Appeal. And then judgment of Lord Nichols, history set out, we've looked at that. He then identified the boundary of the Johnson exclusion at paragraph 27. We just look at that. Well, I mean, as I'm here, I'll just take you to it. Identifying the boundary of the Johnson exclusion area, as it has been called, is comparatively straightforward. The statutory code provides remedies for the infringement of statutory rights not to be dismissed unfairly. an employee's remedy for unfair dismissal, whether actual or constructive, is provided by the statute. If before his dismissal, whether actual or constructive, an employee has acquired a cause of action at law for breach of contract or otherwise, that cause of action remains unimpaired by his subsequent unfair dismissal and the statutory rights flowing therefrom. By definition in law, such a cause of action exists independently of the dismissal. And that, I think, was subsequently, that line was held in a subsequent case called, I think, Edwards and Chesterfield. So you've got the position where the territory occupied by Parliament, in terms subject to a powerful dissent by Lady Hale, is that you can't touch the manner or conduct of the dismissal. But anything prior to that, which is held to be a separate cause of action, is within the term. Then McCabe, the facts of McCabe, same case. He was a teacher. Allegations were made that he'd engaged in inappropriate behaviour with female pupils, as a consequence of which he was suspended. Following disciplinary process, he was dismissed, upheld by the panel, issued unfair dismissal claims in the EET, succeeded based on failures in the disciplinary process. A subsequent appeal to the EAT upheld the findings, but overturned the conclusion of 20% contributory fault. He then issued a civil claim based on breach of contract and negligence. So here we get into trust and confidence territory, focusing on the employer's failure to properly investigate the allegations. Following Johnson, that claim was limited to the conduct prior to dismissal. There was an application to amend the statement of case. It was dismissed and the claim was struck out at first instance. Court of Appeal allowed his appeal, concluding that the case should proceed in order to determine whether the act of suspension was part of the process of dismissal. The employer appealed, and then we've looked at the law we've looked at the legal implications of that. He looked at the boundary. So that was the facts of McCabe. Then we get to Deadman, and Deadman, facts of that. Oh, sorry, let me tell you where it is. Tab 26, so same volume. Tab 26, volume 3, 1084. So Mr. Deadman was employed by the City Council for about 30 years. An allegation was made that he had acted inappropriately towards a colleague, amounting to sexual harassment. There was a formal investigation that was carried out in breach of the council's procedures, and that found against Mr. Deadman, but it was subsequently overturned by a further committee. Then there was a question into whether there should be a fresh investigation. The council decided to convene a new panel to investigate and just left a letter to that effect on his desk. Mr. Deadman said he found the process very stressful. As a result, he spent significant time unable to work at home. Before ceasing to work permanently as a result of depression, he then sued for personal injury. At first instance, the judge concluded that the council had breached his contract of employment in two different ways. First of all, the conduct of the investigation, convening a panel of 2 members, not 3, and then the manner by which it informed him of the renewal of the investigation. The employers appealed, and they succeeded. And again, it was Lord Justice Moore-Bick. And he allowed the appeal, concluding that the manner in which Mr. Deadman was informed as to the renewal of the investigation did not constitute a breach of the contract. And that you find at MS 1084, last paragraph of the headnote. And then as to the letter, you see that at paragraph 42, MS 1090. And then he finds at paragraph 46, last two lines, that the failure to convene a panel of three did amount to a breach of contract, but the psychiatric damage that flowed was too remote. Now, in relation to the T&C term, we look at paragraph 12, and at paragraph 12, take it from the semicolon about 4 or 5 lines down, an implied term of mutual trust and confidence, which forms part of the contract of employment itself and a general duty imposed on the employer by the common law to take reasonable care to avoid physical and mental harm to his employees. As to the former, it's now well established that a contract of employment contains an implied term that neither party will, without reasonable cause, conduct himself in a manner likely to destroy or seriously damage the relationship of trust and confidence. That's Malik, which you've already seen. The practical consequence of what Lord Nichols described in that case as a portmanteau obligation are many and various, but I have little doubt that they include dealing with personal disputes and difficulties between employees in a way that is conducive to their individual well-being and the well-being of the employer's own enterprise. So far, even though there would be a potential conflict wrapped up in that, so far as that is reasonably possible, the contract of employment is also subject to an implied term that the employer will take reasonable care for the health and safety of the employee. The term covers broadly the same ground as the employer's duty of care under the common law, so that in practice it is usually a matter of indifference whether the employee who has suffered injury at work sues in contract or tort. See the comments of Lord Justice Clark in Martin against Lancashire County Council. And that's all we take out of Deadman. Then we got the last one is a rather complicated case of Yap. The fact that that's at tab 49 of volume 5.
Well, you're nearly at the end of your time, so would you prefer to leave Yap until
I'm delighted to leave Yap.
You're delighted, are you?
I'd be delighted to leave Yap until tomorrow. Yap is a bit of a nightmare in terms of a rather complicated case, which we've attempted to. You'll be able to read it if you wish this evening.
If it's a complicated case, we'd no doubt prefer to hear from you about it tomorrow.
Thank you very much.
Thank you.
And I can assure you I will finish within my time and attempt to answer all your questions.
Well, we'll try and think up some really difficult ones for you.
I look forward to them.